everyone, and welcome back to the channel. Liberty Baby, as you can see, is joining me today to bring you a bit of good news that just came out on Tuesday, April 25th. Yes, it's very exciting. Hopefully I can get this out same day, but we all know it's the little boss that decides and not me. Also, not gonna lie, hoping the baby's presence distracts you from the fact that she just put cream cheese in my hair. Anyway, the good news is that the ATF's bump stock ban got another strike against it. Before I get into the details of what happened and what it means, I'd like to thank today's sponsor, Battle Cat Company. Battle Cat Company is a Virginia-based company specializing in gear for the warrior community. Their products are made by patriots, for patriots, and they strive to make every single order as awesome and as packed with tactical goodness as possible. To check out all they have to offer, use my link in the description and the pinned comment. Don't worry, she's hanging out right there. So, what happened and what does it mean? The case Hardin v. ATF just got through a 3-judge panel in the 6th Circuit Court of Appeals. Short version is the panel ruled that the ban is unconstitutional and kicked it back to district court for reconsideration. Yeah. For those not familiar with the case, Scott Hardin brought an action against the ATF in the Western District of Kentucky after they suddenly decided in 2018 that bump stocks are machine guns when previously they said that bump stocks were not machine guns. The district court ruled against Hardin and he appealed. Hardin argued that the definition of a machine gun in the NFA excludes bump stocks, while of course the ATF argued the opposite. This is an argument that has been had many times, with opinions split every which way from Sunday, which the decision notes. From the opinion, the placement of a bump stock on a semi-automatic rifle causes the rifle to function essentially like a machine gun by dramatically increasing the rate of fire, and the possession of a machine gun is a criminal offense under the Gun Control Act of 1968. This raises the question of whether a bump stock is a machine gun part, as defined by the National Firearms Act of 1934. The question is a close one on which reasonable jurists have disagreed, a disagreement caused by ambiguities in how the applicable statute defines the term machine gun. An act of Congress could clear up the ambiguities, but so far Congress has failed to act. The Bureau of Alcohol, Tobacco, Firearms, and Explosives has been on both sides of the issue with its current regulation, the rule, banning bump stocks as a machine gun part. In this situation, the rule of lenity that is applicable to criminal offenses requires us to rule in favor of Hardin. We therefore reverse the judgment of the district court and remand for further proceedings consistent with this opinion. So what does that mean in normal, not lawyer speak? In other cases, the courts looked to the Chevron case, notably when the Supreme Court ruled against the EPA and said they didn't have the power to regulate XYZ. But it was decided that that didn't qualify here because both parties didn't use it to their defense, basically, and because the particular charges would be criminal in nature. So instead, the court looked to the rule of lenity, which basically means when it comes to criminal statutory interpretation, if the law is unclear or ambiguous, the court has to apply the law in the way that is most favorable to the person facing the charges, which, in this case, is Hardin. Now, this doesn't mean that bump stocks are suddenly legal. 2 circuits have found the ATF rule illegal, but no one has ordered the ATF to stop enforcing it, which, it turns out, is another thing entirely. This decision simply sends the ball back to the district court to reconsider based on the decision that the rule is illegal. There's also speculation that, because 2 courts say it's illegal and other courts say that it is legal, that the Supreme Court has to take it up to give the final say. It was also noted in the analysis that there have been 22 opinions on the definition of machine gun, taking up nearly 350 pages between all of them. And there is no consensus beyond the fact that the definition of a machine gun is ambiguous. The opinion states that the only way to settle this would be with a Supreme Court decision. There's also some speculation that this could be used to help appeal in the Matt Hoover auto keycard case, which I'll link up here if you haven't seen my video. It's not the same district, but could be considered. It also could be used as precedence against the pistol brace rule, but all of that remains to be seen. In the meantime, thanks for tuning into this video and joining me and Liberty toddler, I guess, on today's little YouTube adventure. Please like and share this video, drop a comment for the algorithm, visit today's sponsor, and as always, I'll see you on the next one, and happy shooting.